Welcome, class, to today's Explainer. I am absolutely thrilled you're here. Today, we're diving into a masterclass on the fascinating and, honestly, sometimes heart-wrenching human drama behind English trust law. We're going to look way past the dense legal jargon and examine the actual people. The fathers, the nuns, the estranged husbands, whose real-life actions shaped the very rules of how property is given, protected, and sometimes lost forever. So let's jump right into this.
Here's our syllabus for this session. We'll start with a welcome to trust law, then move into constitution and imperfect gifts. After that, we'll tackle the three certainties: intention, subject matter, and objects. And finally, we'll wrap up with a final review and takeaways.
Section 1, Welcome to Trust Law, the Rules of Giving. What's truly incredible about trust law is how casual promises made over a kitchen table can literally transform into legally binding obligations. But before we get into the case law, let's nail down our core term. An express trust is basically a legal mechanism where a person, the settlor, transfers property to a trustee. The trustee's job? To hold and manage that property strictly for the benefit of the beneficiaries. It essentially splits the ownership of the property into legal title for the trustee and beneficial or equitable title for the beneficiary. The stakes here are incredibly high, guys. If this mechanism succeeds, fortunes are protected. If it fails, well, millions can just vanish. Section 2, Constitution and Imperfect Gifts, the point of no return. In this section, we're looking at the exact moment a gift is truly given and when it permanently transforms into a trust. Let's kick things off with our first major precedent. The citation is Re Bowden, a 1936 Chancery case. Here are the brief facts. Back in 1868, a woman who was about to become a nun made a voluntary settlement. She promised to put future property she expected to inherit from her father into a trust. Later on, her father died, and his executors actually transferred those funds to the trustees. Fast forward decades later to 1936. The settler leaves the convent and demands her funds back. The issue? Can she reclaim her money? Well, what the court held was a firm no. The property had been received by the trustees with valid authority, meaning the trust was fully constituted. The core principle here is absolutely crucial. A voluntary trust, once validly constituted, is strictly irrevocable. You can't just change your mind and hit undo. Now, consider the sheer drama of our next precedent. The citation is Jones v. Locke, an 1865 case. The brief facts are kind of heartbreaking. A father, Robert Jones, comes home, puts a 900-pound check right into the hand of his infant son, and says, "Look you here, I give this to baby for himself." He then takes the check back, tells the nanny he's going to put it away for his son, and locks it safely in a safe. Tragically, Jones dies just a few days later before ever formally endorsing that check. So the issue, did this loose conversation create a valid immediate gift, or maybe a valid trust for the baby? What was held? Neither. The gift totally failed because the check wasn't formally endorsed, and the principle here is that courts flat out refuse to interpret a failed gift as a valid declaration of trust. And that leads us directly to the bedrock citation of Richards v. Delbridge from 1874. The brief facts. A grandfather intended to give his business to his infant grandson, but completely failed to properly transfer the legal title. The issue? Could that failed gift magically become a trust to save the day? What was held? The court said no way. The principle established here is firm. Equity will not perfect an imperfect gift. If your intention is to make an outright gift, but you mess up the paperwork, the court is not going to retroactively declare you a trustee just to save the transaction. You really have to show a clear intention to act as a trustee from the start. Section 3, the certainty of intention. Did you mean to do that? Now we are entering the territory of the famous 3 certainties required for any trust. The question here is simple but profound. Did you actually mean to do that? We're focusing entirely on the specific words and actions of settlers. Let's look at the landmark citation of Paul v. Constance from 1977. Brief facts. Mr. Constance was separated from his wife and living with a new partner, Mrs. Paul. He had a bank account in his sole name, but he frequently told Mrs. Paul, "The money is as much yours as it is mine." Sadly, when he died, his estranged wife swooped in to claim the funds. The issue here, did Mr. Constance's informal chat create an express trust for Mrs. Paul? What was held? The Court of Appeal held, yes, it absolutely did. The vital principle here is that an express trust can be created without formal written legal jargon. Repeated statements in conduct can totally serve as an express declaration of trust. But hey, words can be super tricky, especially precatory words, words of hope or desire. Let's compare 2 vital citations side by side to see why. First, Re Adams from 1884.
The brief facts: a man left property to his wife in full confidence she would do what is right for their children. The issue: did these specific words create a trust? What was held? The court held this was just an absolute gift to the wife, with absolutely no binding trust. Now contrast that with a citation of Comiskey v. Bohr and Hanbury from 1905. The brief facts: property was also left in full confidence. The issue: did this phrasing create a trust? What was held? The House of Lords held that the overall context of the will actually showed an imperative, mandatory intention, meaning a trust was indeed validly created. The principle here is that courts don't just hunt for magic words, they look at the entire context of a document to find the true intention.
And let me tell you, courts are exceptionally good at sniffing out true motives. Take this citation of Midland Bank v. Wyatt, a 1995 case. Brief facts: Mr. Wyatt signed a trust deed giving his house to his family, shoved it in a safe, and never acted on it, doing this purely to shield his assets from business creditors. The issue: was this a true trust? What was held? The court held this was a complete sham because there was no subjective intention to actually create a trust. Contrast that with the citation of Re Kayford from 1975. Brief facts: a mail order company facing insolvency took customer prepayments and put them into a completely separate bank account just to protect those customers. There was no formal trust document at all. The issue: did their protective actions create a trust? What was held? The court held a valid trust was formed. The core principle here is that the intention to create a trust can be inferred simply from protective conduct, even if you don't have a single formal document. Section 4. The certainty of subject matter. What exactly are we trusting? Look, good intentions mean absolutely nothing if we don't know what property is actually involved. What exactly are we trusting? The law demands precision here. Take the 1854 citation of Palmer v. Simmons. Brief facts: a trust was attempted over, quote, the bulk of an estate. The issue: was the property certain? What was held? The court held the trust failed entirely because the bulk is an undefined portion. Or look at the 1789 citation of Sprange v. Barnard. Brief facts: a testatrix left her husband property for his use and said the remaining part of what is left should go to her siblings. The issue: was the trust property identifiable? What was held? The court held this failed too. Because the husband could spend whatever he wanted, it was literally impossible to know what would remain. The principle here: trust property must be mathematically or physically identifiable at the exact moment the trust is created. Period. To see just how brutally strict this is, consider the tragic puzzle in the citation of Boyce v. Boyce from 1849. Brief facts: a father left houses in trust. His daughter Maria was to choose one house for herself, and all the remaining houses would then go to his other daughter, Charlotte. But Maria died before her father, so she never actually chose a house. The issue: which houses belonged to Charlotte? What was held? The holding was devastating. Because Maria never made a selection, the remaining houses for Charlotte simply could not be identified. The principle here is that if the mechanism to identify the property fails, the entire trust fails for uncertainty of subject matter. Section 5. The certainty of objects. Who gets the benefit? A trust is an obligation, right? And trustees must know exactly who they owe their duties to. Who actually gets the benefit? Well, for a long time, the law was incredibly rigid on this. Look at the 1955 citation of IRC v. Broadway Cottages. The facts involved a fixed trust. The issue: how certain must the beneficiaries be? What was held? The court established the complete list test. The principle here is that for a fixed trust, you must be able to draw up an exhaustive, complete list of every single beneficiary. Otherwise, the trust fails. But let's contrast that with the 1970 landmark House of Lords citation, McPhail v. Dalton. The facts involved a discretionary trust, where trustees actually choose who gets what. The issue: did discretionary trusts also require a complete list? What was held? The Lords held they did not, completely shifting the law to the any given postulate test, or the is or is not test. The principle here is that a discretionary trust is valid if you can say with certainty whether any given individual is or is not a member of the beneficiary class. It only requires conceptual certainty, a real game changer. But hold on, there are definitely limits to this flexibility. The citation is R.V. District Auditor ex parte West Yorkshire Met County Council from 1986. Brief facts: the council tried to create a trust for the benefit of all inhabitants of West Yorkshire, which was roughly 2.5 million people. The issue: could a trust with a class this wildly large be valid? What was held? The court struck it down. The principle established here is administrative unworkability. Even if you know the class and have conceptual certainty, if it's so massive that a court could never practically supervise or enforce the trust, it's just void. Finally, We have the citation of Reed Barlow's will trusts from 1979. Brief facts. Helen Barlow left an art collection and allowed her family and friends the option to buy paintings at a deeply discounted price. The issue is the term friends too conceptually uncertain to be valid? What was held? The court actually held this was valid. The principle here is that a conditional gift does not require the strict conceptual certainty of a discretionary trust. The trustees didn't need to map out the whole class of friends. Anyone who could step forward and prove they met a reasonable definition of a friend satisfied the condition precedent. It's a subtle but absolutely critical difference that actually saved the gift.
Section 6, Final Review and Takeaways. Court is adjourned. Well, class, we have covered a ton of ground today. It's time to consolidate everything we've learned into practical principles you can actually take with you. Here's a summary of the brutal, yet highly logical strictness of English trust law. First, once a voluntary trust is fully constituted, it's irrevocable. You literally cannot change your mind. Second, always remember Richards v. Delbridge. Equity will never, ever perfect a failed imperfect gift. Third, when looking for the certainty of intention, courts won't just look for magic words. They're going to examine the entire context and conduct, just like we saw in Paul v. Constance and Re. Caford. And finally, both the property and the beneficiaries must be strictly identifiable at the time of creation, or the whole shebang fails.
Now, I want to leave you with a really provocative thought. We saw in Paul v. Constance that a completely informal conversation, just saying the money is as much yours as it is mine, created a fully binding express trust. Think about the casual texts and emails we all send today. Given how heavily courts infer intention from conduct, could your everyday digital language accidentally cross the line into legally binding territory? Honestly, it's something to think about the very next time you hit send. Thank you so much for joining me for this explainer, and I will catch you in the next one.